About 4 minutes past 12. So I'll now formally open this webinar dealing with the rule of law. My name is Anthony Wheely, QC. I have the privilege of being the chair of the Centre for Public Integrity, and it's my task to chair this meeting today. Our two speakers are Professor Toomey and the Honourable Stephen Charles, both of them distinguished Australians, and I'll introduce them formally in a minute. But before I do that, at the outset, I would like to acknowledge the traditional custodians of the lands on which each of us gather today and pay respect to their elders past and present. In particular, I wish to acknowledge any Aboriginal people who are participating in this webinar. Now, as I've said, the rule of law and its enduring quality in our democratic society is a topic of the utmost importance for Australians. And two speakers today will have very valuable input and I think interest you all in relation to their views on this topic. Professor Toomey will speak first, and she'll then be followed by Stephen Charles. And towards the end of their presentations, I will be asking for questions. As always, there will only be a limited time for that. So we'll try and choose the questions that seem most pertinent to the topic today. But for the moment, may I introduce Professor Toomey, AO. Professor Toomey is a Professor of Constitutional Law and the Director of the Constitutional Reform Unit at the University of Sydney. She's practiced as a solicitor, and she's worked as a researcher for the High Court of Australia and the Commonwealth Parliamentary Research Service. She has served as Secretary to the Senate Legal and Constitutional Committee, and she has acted as a consultant to various government bodies. Last month, Professor Toomey was appointed an Officer of the Order of Australia, and we congratulate her on that appointment. Well deserved, Professor Toomey. The Order of Australia award was given to her for distinguished service to the law, to legal education, to public education on constitutional matters. Recently, Professor Toomey has published a valuable paper entitled Constitutional Risk, dealing with the rule of law and the prospect of democratic decay. It is my understanding that she will speak to some of those matters in that published article during her talk today. So now may I welcome Professor Toomey.
Thank you very much. Indeed, I will be talking about that paper today, and I'm also fulfilling my role of public education on constitutional matters, so I am at least living up to my AO. Right, well, while there has been a great deal of debate about what the rule of law actually means, one thing is certain, and that is that it requires that government cannot dispense with the rule of law or cannot dispense with laws and must itself obey the law, and that includes the Constitution. Now, despite this certainty, governments in recent times have taken a much more cavalier approach to the rule of law. They instead ask what they describe as the rule of constitutional risk. Now, this involves assessing not only what the risk is that the Commonwealth is acting unlawfully in relation to particular actions, but also the risk that someone will bring legal proceedings that reveal that the government is breaching the law. And if that risk is low, then the government is prepared to continue acting unlawfully. Essentially, it seems that the rule of law has been replaced by the rule of what you can get away with. Now, this is starkly evident when it comes to funding grants to community bodies. Governments these days make grants blatantly and unashamedly on the basis of obtaining political advantage rather than on the basis of merit or need. Now, this results in the unfair distribution of public funds, the funding of unworthy or even unviable projects. We often see funding withdrawn because it was never possible to do the project anyway, the inefficient allocation of scarce resources, poor planning, and a lack of coordination with other levels of government in providing appropriate local facilities. In short, it results in bad government. Now, the exorbitant costs of such schemes, which now runs into billions of dollars, also imposes a heavy economic burden on the country, and particularly on future generations. During a time when governments are having to run huge deficits to deal with a pandemic, you would imagine that some effort would be made to pull back on unnecessary and wasteful spending of public funds for political advantage. But no, the younger generation will pay, and will pay enormously in the future, for the profligacy of government vote buying schemes today. And let's be clear, these schemes are primarily used for vote buying. The sports rorts scheme to swimming pools and car parks, none of these schemes fall within Commonwealth areas of policy responsibility, and all of them have involved grants being made, announced or promised prior to elections, where the money has been largely targeted at particular seats held or desired to be held by the party in government. We've seen the colour-coded spreadsheets. We've read the Auditor General's reports. There is just no hiding this. Economists have also shown that such spending can shift votes up to around 2%. And in a tight electoral contest, whichever party has the advantage of incumbency, and remember, it might be the party that you oppose, whichever party has that advantage can use public money to buy an election outcome. Now, politicians do it because it is effective at distorting democratic outcomes. They know this. It is not a miracle outcome. It is an election which is bought by taxes paid by hardworking Australian families. Now, most recently, it was suggested that the fact that the government won the election was justified such actions, the effect of laundering the misuse of public money in vote buying exercises because the exercise was successful. In my opinion, using public money for political party gain rather than public good is never acceptable, especially if it is successful in altering the democratic outcome of elections. But beyond the ethics of such behaviour is the issue of the rule of law. Is it lawful? And why does no one seem to care that it's not? The Commonwealth's Community Sports Infrastructure Grant Program, which is colloquially known as Sports Rorts, provides a classic example of breaches of laws and self-imposed government standards on multiple levels. The problems revealed in this program turn up in different combinations in various other programs. So not all of them will appear in car parks, etc., but some of them do in different variations. And these affect grants on swimming pools, regional grants, community grants, safer community grants, car parks, etc. Now, the problems are endemic throughout the system, and the flagrancy of the breaches is growing. Indeed, on the same curve as the coronavirus has been growing in Sydney, and that is exponential. So let's start with the Constitution. The first problem is the breach of Australia's most fundamental law, the Constitution. Now, it must be screamingly obvious to anyone without any training in constitutional law that the people who wrote the Constitution would not have intended or authorised the Commonwealth to deal with local matters such as resurfacing the local footy oval or constructing the local car park. Unsurprisingly, they gave the Commonwealth the power to deal with matters that involved international matters such as external affairs, aliens, immigration, defence, etc., matters that cross state boundaries, interstate trade and commerce, interstate industrial disputes, and things that need to be dealt with in a unified way across the country. So your currency, intellectual property, marriage. The Commonwealth Parliament was limited to specific heads of power and everything else was left to the states, including the establishment of local government to deal with local matters. Now, while some small aspects of the Commonwealth sports funding program might be supported by the External Affairs Power to the extent that they give equal access to sporting facilities to women and the disabled in accordance with some treaty obligations Australia has, the vast majority of grants do not fall within Commonwealth power and are simply unlawful. The High Court made it very clear in a number of cases in recent times, the Pape case and the Williams cases, that the Commonwealth Parliament must legislate to authorise the making of grants, and that legislation has to be supported by a Commonwealth head of power. The Commonwealth government, however, does continue to defy the High Court and keeps on spending on subjects that are not within its competence based upon this notion of constitutional risk. The calculation is that the only people who will have standing to challenge these grants are the recipients of them, and no one who is given a present rejects it and then sues the government for giving it to them, unless you're Brian Pape or Ron Williams, two extraordinary outliers in relation to these matters. Now, what is most interesting to me anyway, is that while constitutional scholars, so that not just me, but also Cheryl Saunders, Michael Cromlin, Jeff Lindell and others, have raised concerns about the invalidity of these grants on numerous occasions, including to parliamentary committees, the opposition makes very little of it, and it's not pursued, unlike all the complaints about bias in the giving of grants. There's plenty of noise and anger about that, but virtually nothing on the legality of the grants. Why? Because the opposition also has an equal interest in unlawful spending in the future. They anticipate that someday they'll get back into government and they can then do the same things. Neither side seems to care sufficiently about the importance of the rule of law to put a stop to these breaches. Now, while the Audit Office has done sterling work in calling out bias in the application of grant money, along with inefficiency and waste, it does not make any assessment about the constitutional validity of the funding or even its legality, because it does not have the legally qualified staff to do so. At most, it raises queries about the legality of grants, as it did in relation to the sporting grants program. In the absence of some kind of independent determination of unlawful behaviour, it is very hard to pin consequences on the government for their actions. But the obvious disrespect for the rule of law still does have an effect, even if it's not reflected in the ballot box. It seriously erodes public trust in government and compliance with the law by the public. People think, well, why should I have to obey the law if the politicians don't? And this is how corruption flourishes. It starts from the top. The more respect for the rule of law is eroded by people seeing it flouted on a regular basis by those who are in charge, the more we head into third world levels of corruption and graft. It is a dangerous path that our politicians are blithely pursuing simply to gain advantage at the next election. And I have to say, I ask myself frequently, don't any of them care about the serious damage that they are doing to the system of government by eroding respect for the rule of law? Do any of them think at all beyond the idea of winning? The notion abounds amongst politicians that the means are justified by the ends, that it's okay to abuse the rule of law and to make unlawful grants to buy an election outcome, because in the end, the success of your side in that election is for the benefit of the country. Even if that were objectively true, and people can have different views about it, in the short term, it is not true in the long term. The erosion of the rule of law and the seeding of future corruption are profoundly worrying. We are set on a trajectory with horrific ends, yet our own leaders cannot see beyond the immediate glittering prize of the next election. Now, the sports rorts scandal revealed more than breaches of the Constitution. It showed failures as a matter of law on multiple levels. So first here we start with lawful authority. There was no lawful authority for the minister to make the grants. And this is because the statute allocated the grant-making function to Sport Australia, a statutory body, and the funds were appropriated to it to spend, not to a government department and not to the minister. The minister had limited powers under the Act to direct Sport Australia. Any directions had to be in writing, had to be tabled in Parliament, and no such directions were made. There was no power for the minister to act as the delegate of the Commission in deciding which bodies were funded. The minister and Sport Australia could not even get their stories straight about how the minister was entitled to act as she did. She said she relied on executive discretion. She's the minister, so therefore she gets to tell departments, etc., what to do. Except this wasn't a department. It was a statutory authority, and there was a statute which specifically limited her powers. Whereas Sport Australia argued that the minister wasn't making the decisions, even though the minister argued she was making the decisions. Sport Australia said that they just coincidentally changed all their decision-making to match her suggestions. Basically, the minister exercised a power because she wanted to, even though she had no legal power at all. It was unlawful. But neither the public servants nor Sport Australia called it out and stopped the minister. Indeed, Sport Australia actively facilitated it by abandoning its own decisions as to who should receive the grants and replacing them uniformly, 100%, with the decisions of the minister. Now, this suggests an overly compliant public service because the minister's own department did nothing about it, and a servile statutory body. None of them were prepared to enforce the rule of law in the face of a ministerial desire to act contrary to it. The next area where there was also potentially breaches is in relation to financial legislation. There are legal obligations on ministers about approving and making grants under the Public Governance Performance and Accountability Act. Ministers must be satisfied that the spending of public money is efficient, effective, economical, and ethical. Grants made for political advantage in targeted seats are unlikely to satisfy those requirements. While there is no associated penalty in the Act for breaching that provision, it is still a legal requirement. It is law. Ministers are, according to the rule of law, required to obey the law, regardless of the existence of penalties. In addition, breaching this particular law would also be relevant to any administrative law challenge to their decision-making. All right, next point, further area where there were breaches, grants rules. At the Commonwealth level, the grants rules are statutory rules and therefore have the effect of law. Ministers cannot approve grants without receiving written advice from officials on their merits and must record in writing the basis of the grant guidelines and the key principles of achieving value for money. Now, these are very sensible and appropriate rules. If ministers report to the finance minister giving their reasons. Now, in the case of the sports grants, it was claimed that these rules did not apply. Why? Because it was a statutory authority rather than the minister who was making the decisions, despite the fact that the minister thought that the minister was making the decisions, and so did Sport Australia. Nonetheless, at least on my reading of the rules, they did apply to the minister in these circumstances, and the minister did not comply with them. And even if they didn't apply, Sport Australia had an equivalent set of rules, and there was no compliance with their rules either. Finally, we get to the issue of administrative law. Yes, it is law. When ministers are decision makers, or even when public servants are decision makers, they must obey the rules of procedural fairness. They must act within their legal power. They must not act for an improper purpose. They must not take into account irrelevant considerations. They must not act in a biased way. And let's face it, it would be difficult in the face of the Auditor General's report to see how the minister's behaviour was consistent with all of those standards. So you see on multiple levels here, serious problems in relation to the rule of law and the application of it in relation to this example. So some suggestions as to what should be done about it. Okay, first one, and you may think this is a bit odd, but I think it's actually really important, education. We need to educate ministers and their advisors, so the people in the ministerial offices, as to the constraints on ministerial power. It became apparent during the parliamentary committee hearings that the minister had no idea about the true scope of her powers and saw legality as a mere technicality which should have been sorted out by somebody else. Okay, I'm the minister, I get to exercise my powers. If there are any problems, somebody else should deal with it, but I should still be able to exercise the powers the way I want. The only education that ministers actually receive is in how to obtain power. They're very good at learning how to climb the greasy pole, but most of them are clueless as to how the government system works and how they must exercise the very considerable powers that they do receive, particularly under statute. Now, the importance of the rule of law and the obligation to comply with it needs to be explained and impressed upon ministers. Secondly, public service independence. There needs to be more done to ensure that public servants are obliged by law and as a condition of their service to inform the minister about any legal constraints on his or her power. They should also be protected from retaliatory action for giving ministers advice that they don't want to hear. All such advice should also be in writing and, critically, made available to any investigating parliamentary committee. Only then can there be proper accountability of ministers to Parliament. In the sports grants controversy, far too much material was refused to be produced by the government to the parliamentary committee that inquired into it, including all the legal advice, to the extent that there was any. Thirdly, the Auditor General's Office needs to be properly funded through an independent method and to be fully staffed, including with a legal branch, so that people can actually make assessments as to the likely lawfulness of government action and the constitutionality of government spending, which is something that is not assessed. Fourthly, we need an effective and properly funded independent corruption commission to investigate allegations of corruption and to make public fundings. And finally, we need legislation to be enacted to govern the grants process in a comprehensive manner so that grants are only given on the basis of merit and public need, following applications that are assessed by reference to publicly advertised criteria, following appropriate consultation with other levels of government. There should be no exceptions for election promises or because the administering body is a statutory body. So let me conclude here with just a couple of observations. First of all, if you raise these kinds of concerns with politicians, first of all, they'll roll their eyes and say you're terribly naive. And then they will say, first of all, well, the other side does it or will do it, so we should too. Now, look, frankly, you wouldn't accept such an argument from a 10-year-old. So you shouldn't accept it from politicians either. Next, they will say, well, these are all just technical rules and the ordinary people don't care about that. They just want stuff done and they don't care what level of government does it. So why shouldn't the government Commonwealth fund these things rather than state or local government? But I think if you took a straw poll of whether ordinary people think that politicians should obey the law and the Constitution and not use public money for their own political advantage, I'm pretty confident that they would agree and that they would care. Finally, politicians will say, oh, look, these are all good projects and we shouldn't be depriving people of football ovals or car parks, and your proposals would mean that nobody would get this money or these facilities. Well, look, if they are good projects, they can still be done through lawful means. Grants can be made to local governments through states under Section 96 of the Constitution to fund local sport, local car parks, and it can be done on the basis of merit and need in a properly coordinated and effective way. Complying with the law does not mean denying people facilities. On the contrary, it's in fact likely to result in more and better facilities because the money is more likely to be spent in an efficient, properly planned manner. But then the Commonwealth politician will argue, well, what is to stop the state or local government from applying the money, grant money, to their political advantage? So this is getting back to your 10-year-old's argument of saying, well, hang on a minute, if then somebody else does it, they'll do it corruptly, so I should be able to do it corruptly instead. Again, the answer here is proper laws and conditions being placed on funding to require that it be spent according to clear criteria and be done appropriately. Ultimately, there is no excuse for the abuse of government grants. It is wrong at every level. But worst of all, it undermines the rule of law and it destroys trust in the democratic system of government. Thank you very much. I'll end my rant there.
Thank you very much, Professor Toomey. I mean, what you've said, I think will give everybody who's watching, more than 150 people, some considerable food for thought. And your suggestions at the end are rooted in decency, integrity, and common sense. And if only we had 150 politicians at federal level listening to us, maybe it'd make a difference. So now I turn to the Honourable Stephen Charles, AO QC. Stephen was admitted to the Victorian Bar in 1961, became a Queen's Counsel in 1975, had an exceptional career as a barrister, including becoming the chair of the Victorian Bar and the president of the Australian Bar Association. In 1995, he was appointed a foundation member of the Victorian Court of Appeal, where he served with great distinction until his retirement in 2006. He was awarded an Order of Australia in 2017, and in 2019, he became one of the foundation directors of the Centre for Public Integrity, and he's worked tirelessly on issues of integrity, honesty, and accountability ever since. So it gives me great pleasure to now call on Stephen Charles to address the issue of the rule of law.
First, I would like to say that I agree with every word that Anne has said before me. I hope you heard that. Now, I want to start with what does the rule of law mean? Now, it means many things, but it certainly means that all persons within the state should be bound by and entitled to the benefit of the laws of the state. Secondly, the laws of the land should apply equally to all. Third, law must afford adequate protection of fundamental human rights. Fourth, prosecutorial procedures in the state must be fair, they must be, and justice must manifestly and undoubtedly be seen to be done. And fifth, the state must comply with its obligations in international law, including whether deriving from treaty or international custom or convention. Now, does the present government abide by the rule of law? The Prime Minister repeatedly tells us that we live under the rule of law. This government only abides by it when it suits it. Now, for example, 1, robo-debt, an illegal attempt by the Commonwealth to impose on many in the community debts assessed by a machine without any legal sanction or court order, supervised by, among others, the Prime Minister and Stuart Robert. It caused immense distress, including a number of suicides. Second, before the last election, the coalition, believing it would lose office, appointed over 50 persons to the administrative appeals tribunal, nearly of whom were known to be supportive of the coalition's views and opponents of asylum seekers. Third, Australia's contemptible treatment of asylum seekers. For long periods, a large number, including children, were detained offshore in detention camps, the government's attention being to inflict deliberate cruelty to keep them as far as possible away from legal advice and medical treatment, and the policy being intended to be as cruel as the government could get away with. Lord Bingham, the former English Chief Justice, said a state which savagely repressed or prosecuted sections of its people could not, in my view, be regarded as observing the rule of law. Next, the conduct of several trials in absolute and unnecessary secrecy at recent times on the ground of putting at risk our secret intelligence arrangements. Next, the failure to establish an integrity commission in breach of our obligations under Article 36 of the UN Convention Against Corruption, of which we are a member. And finally, for all the reasons that Professor Toomey has put to you, the sports rorts and the car parks rorts and other such programs. Next, the treatment of Timor, the bugging of the Timorese cabinet rooms during negotiations for a treaty to establish a medium line in the Timor Sea. I won't deal at length with this. The government asserts that it cannot discuss such matters because they involve the activities of our secret intelligence agencies. But if they deny that any such bugging actually occurred, it would have been a very simple matter, either before the International Court or in the press, simply to say the government in its negotiations was never assisted by knowledge of the deliberations in the Timorese cabinet rooms. There have been multiple breaches of the rule of law, both in the treatment of Timor and in the treatment of those who bugged, disclosed the bugging of the Timorese cabinet rooms and their prosecutions since. Now, I want to deal with many other, or some of the many other allegations which have arisen since to justify the establishment of an integrity commission. First, the systemic frauds in the Defence Department, which were reported in the Age of staffers colluding with contracting companies to design well-paid jobs for them. There was an audit then of procurements, which found that 80 breached departmental guidelines, 45 could not be examined because of missing paperwork, and only 79 actually met the department's internal rules. Next, the submarine contract with the French Naval Group. The French Naval Group is lavish in the bribes that it gives to obtain contracts of this kind. Its record is marked by such misbehavior, but in one particular case, for example, in relation to a contract to build frigates for Taiwan, it had admitted that the bribes paid to achieve that contract exceeded $500 million American dollars. Next, the closed tender process for Paladin's lucrative Manus Island security contracts worth several $100 million, the company being registered to a shack on Kangaroo Island. Next, uncontrolled electoral donations. Hundreds of millions of dollars are received in donations around election time. Large donations to parties are usually bribes intended to achieve access and influence not available to the public at large. All parties, other than the coalition, support, and of course Clive Palmer, support the making of such reforms. The coalition does not, being by far the largest recipient of such donations. Next, Hello World, the travel company World, which received a very large government contract amid allegations relating to ministers and coalition interests in the company. Next, Australia's very lax lobbying regime, showing that such oversight as exists is weak, unenforced, and unable to keep track of the revolving door. Next, of course, the sports fraud program.
Stephen, you've accidentally hit yourself onto mute, so we can't hear you.
Is that better? Next, the sports rorts pale into almost insignificance when compared to the car park rorts. Before the 2019 election, the Morrison government committed more than $600 million to build 47 commuter car parks at suburban railway stations, all in vulnerable seats. Now, the ANAO's scathing attack found that experts in congestion, etc., were not consulted, nor were the states. And this, again, is another flagrant example of political corruption. Transparency International defines corruption as the abuse of entrusted power for personal, private, or political gain. As we have heard, Commonwealth executive power does not extend to giving the government unlimited power to spend taxpayers' money. And the complaint about these rorts has been dismissed by Mr. Birmingham, as the Australian people had their chance and voted the government back in. And he refused to rule out the coalition embarking on similar programs in the future. So, having found it worked, we may assume that they will do the same. Now, as has been pointed out, one of the arguments that's made is the other side will do exactly the same. This is precisely why we need a National Integrity Commission to stop both sides engaging in misconduct of that kind. Now, what then has the coalition proposed? Well, there are 4 critical points. The first is the breadth of the jurisdiction. The second is whether the hearings will take place in public. The third is what will happen to the results of investigations. Will there be public reports? And the fourth is who can complain to the Integrity Commission. Well, the jurisdiction must be broad, as also the definition of corrupt conduct. It must be wide enough to cover the exchange of favours. The politician who receives a large donation and wants to do something in return. There is no criminality in the making of a large donation, but the result will often be the tilting of the playing field. The Integrity Commission must have the ability to hold public hearings. They are the key of investigating and exposing corruption. They expose corruption to the public. They increase public trust that allegations are being fairly investigated. They make hearings more effective by encouraging witnesses to come forward. A proposal to close anti-corruption hearings shows a fundamental ignorance of democracy. The public is entitled to know what is being done by their representatives, whether public servants or politicians, especially where public money is concerned. And the findings of the Integrity Commission must be made public. Now, the Commonwealth Integrity Commission proposed by Mr. Porter is divided into halves. The first half deals with law enforcement bodies, like the Federal Police and the Border Force. The definition of corruption in relation to law enforcement bodies is all-embracing. It includes corruption of any other kind. Any whistleblower may complain about law enforcement misbehavior. There is no necessity for any reasonable suspicion. The whistleblower may be anonymous. The investigations of law enforcement officers will be mostly in public, and will be followed by a report which may include a finding that a law enforcement officer was guilty of corrupt conduct. So the half of Mr. Porter's bill, which deals with law enforcement officers, is strong. It can deal properly with law enforcement corruption, and it will expose corruption in that area. Then we turn to the second half of Mr. Porter's bill, which deals with parliamentarians and the remainder of the public service. Here, the definition of corruption is quite different. A criminal complaint cannot be made by anyone, only by an entity, a body like the Federal Police or the Border Force. Only they can complain only if there is a reasonable suspicion of criminal activity. Any person who knows of criminal corruption by a parliamentarian cannot complain directly to the CIC, but must go to one of these other entities. Next, hearings, if any investigation starts of parliamentarians, must be in private. And any report about an investigation into a parliamentarian must not include opinions or findings about parliamentarians. Now, to demonstrate this, I must read to you one extraordinary section in Mr. Porter's bill, section 239, subsection 7, dealing with reports. It says 7, a report under this section must not include any opinion or finding that is critical, either expressly or impliedly, of or a recommendation about a parliamentarian. So, Mr. Porter's reason for this division is that there is much more evidence of corruption in the law enforcement area. There is no body of research which supports this assertion. In fact, we know to the contrary that the coalition's corrupt pork barreling covers many hundreds of millions, if not billions, of dollars. It will be any person who wants to take knowledge or suspicion of corruption by a parliamentarian or the public service, who wants to take it to a body of the integrity body, will have to go to the Federal Police and persuade that body that there is a criminal offence involved. There will be no public hearing and there will be no report, and any report that is made will not include even an implied criticism of a parliamentarian or her staff. So Mr. Porter's Commonwealth Integrity Commission will not permit any investigation, still less report or criticism of electoral donations or of a favour returned or a government contract that showers millions of dollars on a friend or relation of a parliamentarian, or even a sports resort or car park resort, notwithstanding that they are forbidden by High Court authority. As we have already seen, the CIC model prevents nothing short of flagrant criminal activity being investigated, and we already have numerous bodies dealing with the prevention of criminal activity. Now, we know that the coalition was involved in massive political corruption at the time of the last election, and Mr. Birmingham has told us that they may well repeat it because it worked. Now, the purpose of an anti-corruption commission is to discover and expose corruption. Mr. Porter's body will not do so where parliamentarians are concerned. It is there to protect them from investigation. Well, the UN Convention requires Australia to have an effective anti-corruption commission. Recent polling shows that more than 90% of the community want an anti-corruption commission which is effective, in other words, with teeth. Most crossbenchers and the opposition have declared support for an effective anti-corruption commission. Even the coalition before the last election promised a Commonwealth Integrity Commission. Well, why does the coalition now show no enthusiasm at all for such a body and positively opposes one with teeth? David Sharma has said that our model, that is the Centre for Public Integrities, would have a chilling effect on decision-making. He thought that executive and ministerial decisions should only be judged at election time and not otherwise. Well, a strong National Integrity Commission would certainly chill pork barrelling. It should otherwise require decision-making to be done properly. His second point would lead to electors being left uninformed, required to vote without full knowledge of the government's actions in the electoral term. Next, Mr. Porter, while still Attorney General, said that our version of a National Integrity Commission would damage and destroy reputations. But his model is perfectly prepared to require law enforcement officers at any level of seniority to face public investigation and findings of corruption. Further, there is already Commonwealth legislation which provides for the investigation in public of allegations of misconduct against federal judges. Well, are parliamentarians and public servants the privileged few to be protected by this toothless Commonwealth Integrity Commission from investigation and public hearings? The truth is that the coalition's members believe that they have the right to spend taxpayers' money in any way they choose, that pork barrelling returns favours to the large political donors or otherwise, and they want to continue with it. And in fact, they are scared stiff of being exposed by a National Integrity Commission with teeth. There will be no effective National Integrity Commission established under the present government.
Thank you, Stephen. Thank you very much for those compelling observations and remarks. Well, now we've got a few minutes left, so I think there may be some questions here. So let's have a look. One of
the key questions that keeps coming up is what can the ordinary citizen do outside of an election to deal with it. So perhaps if I might just start by responding to that, because I had more of a chance to read the questions while Stephen was talking. I think it's difficult for ordinary citizens, but I think they do play a really important role because they ultimately are the constituents that politicians are trying to get to vote for them. So making submissions, writing to your local MP so that MPs on the ground feel a groundswell of concern from citizens and recognise that there is a need to change the government's course. I think that's very important. So lobbying your local MP, relevant ministers, and also making submissions to parliamentary committees. So when parliamentary committees inquire into these things like the Sports Rorts Affair, etc., just having large numbers of individual written submissions coming from members of the public is actually quite effective in telling politicians that the route that they're going on is one that's not acceptable. So that's one course. Equally, by the way, don't forget about pressuring the opposition, because reform when it comes to issues like anti-corruption bodies, etc., tends to come from, and this is not party political, it comes from whoever's in opposition as opposed to whoever's in government. Because whoever's in government, it's always in their interest not to have one of these things. Whoever's in opposition, however, wants to win government, and it therefore wants to do something that's popular with people to win government. And if an opposition realises that it's popular to put forward proposals to fix the grant system, stop it being rorted, bring in a proper, anti-corruption commission, properly fund the Auditor General, etc. If the opposition realises that those are fundamentally popular policies, then they're more likely to put them in their party platform. And when they do come into government, some stage, then there's a huge amount of pressure on them to implement those sorts of things as government policy. So that is how you actually tend to make these sorts of changes in government policy. It's usually from an opposition, taking them on as a popular thing and then bringing them in when in government, as opposed to someone who's already in government initiating those sorts of things, which is pretty rare. So they'd be my suggestions if you want to add your voice, because it's true, individual voices are, generally not that effective, but collectively they are effective. So, and, in order to be collective, everyone's got to do their bit. So my suggestion, do your bit.
Thank you, Professor. Stephen Charles, what do you think the ordinary citizen can do about restoring integrity and ensuring that we abide by the rule of law, particularly at parliamentary level?
You've got to unmute, Stephen.
Unmute there, Stephen.
Again, making their views known, and in particular, in as public a fashion as possible, and particularly to their local members. But I agree also that it is important. The opposition has said a number of times that they support the proposal for a strong National Integrity Commission. I think that needs to be stressed more, much more loudly. The more they make loud their promise to introduce themselves a strong National Integrity Commission, the more pressure they will then put on the government to respond to that and to explain why it is that they do not want a strong National Integrity Commission. Thank
you, Stephen. Professor Toomey, can I just ask one question myself? And that is, I know you probably haven't had a chance to research as thoroughly the car park grant system as you have done the sports rort, but my question is, can we expect as equally a learned dissertation on the legality or otherwise of that particular grant scheme? Because the government is certainly denying there's anything wrong with it, and they're saying it's wonderful that people can park their cars near a commuter railway station, even though most of the car parks haven't been built and probably won't be. But so can we expect that in due course? You might have a look at that issue as well.
I've had a little look at it so far. Disappointingly, from a constitutional point of view, it probably is valid. And that is because they've actually given these grants to the states under Section 96 of the Constitution. So this time round, they avoided the constitutional bear trap. So I don't think that's an issue in this particular case. But in relation to other things, the Public Governance and Finance Audit Act and all those sorts of things, administrative law, etc., there may well still be issues about it. The other difference with the car parks thing is it comes under different legislation. It comes under legislation for national transport infrastructure. So it's a separate act. And it comes under the bizarre description, I can't remember precisely what it's, something like intermodal facilities. And so these car parks would only be covered under that act if they involve people moving from one form of transport, such as train, to another form of transport, such as vehicle. So to the extent that some of these car parks really didn't have much of a connection with the train station, then they mightn't be supported by the legislation, etc., etc. So there are issues about it, but it's not as flagrant as the sports one. So yes, there's probably less to make out of that one than the others.
All right. Well, unfortunately, we've come to the end of our discussion. I think from looking at the questions that have been raised, a lot of people would like to have a transcript if possible, or at least a link to the two wonderful presentations we've heard. And I think the overriding response has been very, very positive. And I thank you both, Anne Toomey and Stephen Charles, for the tremendous presentations you've given us and the amount of thought you've given to these participants today, more than 150 of them, on issues of such importance in Australia. Thank you both, and thank you everybody who's taken part. And thank you for your enthusiasm in supporting these webinars on integrity. I shall now declare the presentation closed.
Thank you.